Okay, I was going to begin by saying, can I have your attention? But I seem to have your attention. So I'd like to invite Elder Larry Grant up to provide a welcome and a blessing on behalf of the Musqueam. Elder Grant.
Thank you. Good morning, everyone. I'm Larry Grant from Musqueam. Ayasluk is my Musqueam name, and I'd like to do a few words and welcome. CM Nasiaya, Ayasluk, Guanasquich, y Tenitinit from Musqueam. Clark says Joannes, Kiapalano, y Holtimolto, because he looks to the Huinar, Emink Netten, Kushwi to just all stomach from Musqueam. Stack one is Joannes, Kiapalano, sets something neat to swallow, it's a taller, he looks taller, I tap Cassiam Nashaya. And I finish qualifying when see Guasnala, he should eat in a while, Haichka. Just want to say thank you. Thank you to everyone that's here. Thank you for the coordinators for having me here to be a part of the welcoming. I'm Larry Grant. I'm from the Musqueam people who have lived on this land for thousands of years, 4,000 years in our community at Musqueam, and approximately 10,000 years as the delta is being formed. And our ancestor, Cayapalano, the warrior that had met Captain Narvaez of the Spanish and Captain George Vancouver of the English, lived in the fortified site called Gullichan down by the museum, between the Museum of Anthropology and Wreck Beach, lived there with the warrior families. So that was our great-great-great-grandparent that met with the newcomers that first came to this land. So that's a little bit of how long we've been here, where our communities, one of our communities has been. And again, on behalf of the Hunt Camino speaking Musqueam people, I raise my hands and welcome to all of you here, especially to our Minister of Justice that is returning here to campus. So it's really good to see that. I raise my hands and welcome and thanks to all of you here this morning. Hi, Tepewa, Siam, Nasiaya, Tzia, Talat, and Haichka.
Thank you, Elder Grant. And now I'd like to welcome Martha Piper, the President and Vice-Chancellor of the University of British Columbia. Welcome.
Well, thank you very much, Elder Grant. Thank you, Gordon. And thank you all for being here this morning. I truly welcome you to UBC. It's just wonderful to be able to have our own minister here to deliver what we know will be a very interesting address. I also want to thank the Peter A. Allard School of Law for hosting this event. It's a wonderful tribute to the School of Law to have one of their own graduates here with us this morning. Now, some of you know that we have been spending this year celebrating our centennial, and listening to Elder Grant, it makes us extremely young. But as you know, 100 years ago, in 1915, 379 students began their classes at UBC in our first home, the Fairview Shacks. Today, we have over 60,000 students enrolled in the Point Grey campus, UBC Okanagan, at Robson Square, and at the Great Northern Way. We have come a long way. We are celebrating because UBC has developed to be one of the finest universities in the world in a very, very short time. I say short because 100 years hardly registers on the time scale of great universities. Many of the institutions that are ranked among the world's best, such as Harvard, Oxford, Cambridge, or Princeton, are hundreds of years old. I think Oxford is about 1,200 years old. And many that are ranked behind UBC are much older than we are. Today, just to keep you informed, we are ranked by the Times Higher Education Group, which is the group we watch most closely out of England. They rank 800 universities in the world, including Harvard, Yale, Oxford, Cambridge, University of Tokyo, National University of Singapore, Beida, Tsinghua, the big universities. Your university, the University of British Columbia, is ranked 34th in the world. 34th in the world. But here's another statistic I want you to share with your friends, your neighbors, your colleagues, your government, anyone who will listen to you. If you remove and only look at North American universities, so we take out the Oxford, Cambridges, and if you take out the privates, the Harvard, Yale, Princetons, and only look at the publicly funded North American universities, where do you think your university ranks? Number 6. Number 6. Is that amazing? That is amazing. We are keeping company with Berkeley, UCLA, University of Toronto, University of Michigan, and UW, right next door to us. And we're 6th. And I look at that ranking and we're about 2 points behind UW. So I think we're 5th. So think of all the other publics: University of Wisconsin, University of Indiana, University of Illinois, University of Texas, University of California, San Diego, University of California, Santa Barbara. You name them over and over. We are number 6. We are truly remarkable and young. Today we attract research funding of more than $500 million annually, enabling world-class researchers to tackle some of society's most pressing problems. And we have come such a long way in such a short period of time because of you, because of the community that has supported us. This very building, along with, of course, the remarkable Allard Hall, are shining examples of how far we have come. And of course, our Student Union building is amazing. And it's because a supportive community, working with our alumni, working with our students, faculty, and staff, we have all worked to make this university a remarkable institution. In addition to this fantastic welcome center right here for visitors to our Point Grey campus, and a beautiful venue for holding events such as this, we have over 300,000 alumni around the world in over 140 countries. But we're here today because one of those alumni, of the 300,000, a former student, has returned to her home with great honor. The Honourable Jody Wilson-Raybould, Minister of Justice and Attorney General of Canada, is here today with us as an alum, as a former student. And I will tell you, the university is nothing other than its alumni. That's our product. That's what goes out and makes a difference in the world. That's what causes our reputation to be outstanding. And we celebrate her success, and we claim it. We claim it. It is incredibly awarding to see our students graduate and then go forward, becoming leaders, doing good things, and making our society sustainable and civil. UBC is committed to creating an exceptional learning environment that fosters global citizenship and advances a civil, equitable, and sustainable society. So what better example of that mission is our guest speaker. We are so proud of you, Minister, and we are delighted that you are here with us this morning to share with us your view for Canada and the leading role you will play in making Canada the most significant country in the world. I know she's going to be introduced formally. Again, I welcome you all, and I'm delighted so many of you are here with us on this very significant occasion. Thank you.
Thank you, Dr. Piper, President Piper. The message I got from that was that I'm young. That was wonderful. Thank you. I would like to again thank Elder Grant for his words in welcoming us. I'm always conscious of the fact that I'm a visitor and guest on the Musqueam territory. My name is Gordon Christie. I'm the Director of the Indigenous Legal Studies program here at UBC, and it's my wonderful task this morning to introduce our speaker. I'd like to begin by again acknowledging that we are here gathered on the ancestral, traditional, unceded territories of the Coast Salish people, particularly the Musqueam. It's a privilege for the Peter A. Allard School of Law and the University of British Columbia to be hosting the Honourable Jody Wilson-Raybould, Minister of Justice and Attorney General of Canada, Member of Parliament for Vancouver-Granville. I know some of you in the audience are from Vancouver-Granville, so you get to mingle with your own Member of Parliament. The Minister graduated from the Indigenous Legal Studies program at Allard School of Law. Since that program began in 1975, hundreds of Aboriginal students have graduated from the law school, many of whom are now leaders who have helped to redefine Aboriginal legal issues in Canada, including today's esteemed speaker. The Minister is a lawyer, advocate, and leader. As a former regional chief of the BC Assembly of First Nations, she brings extensive experience in law, public service, and First Nations governance to Cabinet. After being called to the bar in 2000, the Minister began her legal career working as provincial crown prosecutor in Vancouver in the downtown court. She later served as an advisor to the BC Treaty Commission, a body established to oversee treaty negotiations in this province. In 2004, the Minister was elected commissioner by the chiefs of the First Nations Summit. Since being elected regional chief of the BC Assembly of First Nations in 2009, she's devoted herself to the advancement of First Nations governance, fair access to land and resources, as well as improved education and healthcare services. The Minister was re-elected as regional chief in 2012 and held responsibilities for governance and nation building on the Assembly of First Nations Executive. She had previously been involved with the Chiefs Committee on Claims and chaired the Comprehensive Claims Joint Working Group. An active volunteer in her community, the Minister has served as director for Capilano College, the Minerva Foundation for BC Women, the Umbelese, probably mispronounced that, Cultural Centre, and the National Centre for First Nations Governance. She was also director on the First Nations Land Advisory Board and chair of the First Nations Finance Authority. She's a recipient of an Alumni Award from the Minerva Foundation and the University of Victoria, and I notice there's an institution missing from that list. The Minister is a descendant of the Muskamak, Zawadane, Nuk, and Likwata peoples. I'm sorry if I mispronounced that. Part of the Kwakwala-speaking peoples up in the, well, how do I say it's, how do you define that geographic territory? Up on the eastern side of the channel between Vancouver Island and over into Vancouver Island. She's a member of the Wewake Nation. I'd like you all to please welcome the Honourable Jody Wilson-Raybould.
Thank you very much. Well, Gaelic Husla, good morning. Certainly it's an honor to be here and to be see so many people gathered on Musqueam territory. I would, of course, like to thank Elder Grant for the welcome to the Coast Salish territory and specifically Musqueam. I am a little bit, I feel really good today. The sun came out because I was, I think, coming to UBC, or maybe it was because the triathlon's happening today. But I wanted to certainly acknowledge Dr. Martha Piper for that incredible welcome and acknowledgement of what a great institution this is, and celebrating the 100 years and welcoming me back here, and to Gordon Christie for that kind introduction. I am, of course, again, pleased to be here, and certainly acknowledge all of the leaders that are in the room, acknowledge my provincial colleague, the Minister for British Columbia, Susan Anton, and certainly wanted to acknowledge all of the students that are here, and all members that live in and around Vancouver. As was said, UBC is my alma mater. Myself and my sister went to law school. We graduated in 1999. It seems like a long time ago. 16 years ago, I guess, is a bit of a long time ago. And before us, my father graduated from UBC Law School in 1973. And the last time I was at UBC was actually after I graduated. I graduated in what they called the bunker at the time. It was a concrete building where trees grew through the windows and the cement, but I received a tremendous education at the university, and certainly has served me well in the work that I've done. A lot has happened since I was last here during the campaign speaking to law students, and I appreciate the opportunity to come here to speak about what our government is doing and to speak about some of my priorities in my role. Still a very relatively new role as the Minister of Justice and the Attorney General of Canada. Of course, it was a great privilege for me to be elected as the first Member of Parliament in the great new riding of Vancouver-Granville, and I was equally honored to have been asked by Prime Minister Trudeau to be the Minister of Justice and the Attorney General. An appointment that I think speaks volumes about how far we've come as a country, as well as the important work that lies ahead. As I've said elsewhere, this appointment is certainly, for me, a personal accomplishment, but I view it not so much a reflection on myself personally, but rather the symbolism of what the appointment itself represents. That in a nation where an Indigenous person who not so long ago could not vote, let alone run for office, or practice as a lawyer, a person against whom the law discriminated, and to a certain degree still does, who fought for years against that law, is now the principal lawyer in charge of administering that law and advising its government on behalf of that very nation. It takes a moment to sink in. Sometimes it is still sinking in. So it's on this thought that I wanted to acknowledge this beautiful hall that we're in, Jack Poole Hall. I think that Mr. Poole, and I know there's people in this room that know him better than I did, would have been delighted that I am speaking here today in my new capacity. He was a man who clearly understood the need for reconciliation with Indigenous peoples and whose efforts with the 4 host First Nations during the 2010 Olympics was exemplary. As Minister of Justice and Attorney General, I am the steward of the Canadian legal system. And while I can think of no greater honor, I am also equally struck by the gravity of the responsibility and accountability entrusted to me, but also the great opportunity. Opportunities that can only be realized through and with focus, hard work, and cooperation with others, many others. For those of you who know me, you know that I've been an advocate for change most of my life. My upbringing, education, professional and personal experiences have all helped shape my worldview and the way that I work, as well as the perspective and the way that I approach my role as minister. In the Indigenous political system in which I was raised, it is in the big house where our laws are made and important decisions taken. In this system, there are no political parties. Rather, there is a belief in consensus. The issues are debated, and while everyone may not agree on every aspect of the decision to be taken, consensus, and if necessary, compromise, is sought in order to achieve balance in society. It helps to ensure that decisions are durable, legitimate, and survive the test of time. Maybe this is because we lived in small villages and people simply did not leave, but I like to think it is because we value everyone's opinion and every voice counts, not just the few. This system, truth be told, contrasts sharply from the partisan nature of the environment in which I am now a part. For me, I do not think I will ever get used to the type of politics or etiquette in the House of Commons, particularly during question periods. It is here where hyperpartisan politics seems to be the order of the day and certainly works against the idea of achieving consensus. That said, I truly believe that most parliamentarians want to work together. When we work together in common purpose and vision, we can achieve amazing things. Canadians definitely want politicians of all stripes to work together with less partisanship, not just in Parliament, but between and among different levels of government. This is something that was made very clear to me during the 11-week election campaign, and this is why the First Minister's meeting here in Vancouver this week, I believe, was so significant. Not just because the First Ministers reached consensus on moving forward on studying carbon pricing mechanisms, but rather because of the fact that they met at all. The first time a Prime Minister has met with First Ministers in over 7 years. The clear message being that we cannot build Canada unless we work together. A message that is broadened when we hear and consider multiple voices. This lies at the core of our Prime Minister's vision and what our government wants to accomplish, as well as my own personal vision. Namely, as Canadians, we must continue to embrace and build on the incredible diversity that is Canada, and in doing so, make us stronger economically, but more importantly, socially, a beacon of hope in an otherwise divided and troubled world. And I know we can do even better as a country. And how can we do better? Since forming government, our team, itself diverse, has begun to re-examine what we do, why we do it, and how we measure success. We are identifying what is working, what is not working, and how we can change for the better. Not simply change for change's sake. For a start, we are broadening the concept of success beyond economic wealth to include physical and social well-being, equality, and fairness. And in measuring this, we are looking to ensure that all Canadians share in this success. This is very important. If a strong economy disproportionately benefits the few, you cannot say this is a just society. Moreover, you also sow the seeds of discontent. A strong economy must always be seen as a means to an end and not the end in itself, the end being a higher quality of life for all. In terms of specific priorities and meeting a vision for a more inclusive Canada, my priorities and those of our government have been shared publicly through the posting of ministers' mandate letters from the Prime Minister. The first in Canada's history that federal ministers' mandate letters have been made public. This is an act that reflects our government's general approach to relationships with Canadians, as with other levels of government and within government, that of being more open and transparent. To aid in these efforts, my office is also looking to be more open and transparent, as well as effective and efficient. To me, these concepts are inseparable. In fact, it is very clear to me that Canadians want to be more engaged in how their nation is governed and discuss substantive policy issues with decision makers on the very matters of concern and issues that affect them. I believe that working with Canadians to better inform Cabinet and to better inform Parliament enriches us all, and better policy is achieved. So all across government, both externally and internally, we have started to consult and to listen more. And people should not confuse the time needed for consultation and reflection with inaction or indecisiveness. Quite the contrary. This is what governing in the modern era demands. People can participate in many different ways. Also, with access to more information, they can see how decisions are arrived at and judge for themselves whether the decisions that are being made reflect one's values. They can also consider what they would have done in the same situation and with the same information. So in my mandate letter, I am tasked to ensure that all decisions made by our government and proposed legislation are compliant with and guided by the Charter of Rights and Freedoms, our commitments, and our values as Canadians. In Canada, as we know, the primary legal expression of our respect for diversity is through the Charter, where, regardless of faith, gender, sexual orientation, or race, all people are able to see themselves reflected in their Constitution, knowing that if you work hard and abide by the rule of law, you will have every opportunity to succeed, confident in the knowledge that your institutions of good governance will protect and support you. In many ways, I see my role as being the ambassador of the Charter. In my mandate letter, it also directs me to review Canada's litigation strategy. And as part of this review, I've already either discontinued appeals or am reconsidering the Crown's position in others. We have taken action on several cases, including our government's duty to provide health care to refugees, the right to wear the niqab in citizenship ceremonies, collective bargaining with public sector unions, abandoning the appeal of the decision to grant Omar Khadr's bail, and the decision not to appeal the Canadian Human Rights Tribunal decision respecting discrimination in Indigenous child welfare. So I'm also mandated to undertake a comprehensive review of the criminal justice system, including sentencing reform over the past 10 years. No small task. Our society has clearly evolved in recent decades. The issues facing Canada now differ greatly from the issues we faced 5 or 10 years ago. As a result, we need to find new and better approaches to address these emerging issues effectively. So I'll now turn to 2 issues that are dominating headlines: the legalization of marijuana and medical assistance in dying. As you're probably aware, our government has committed to legalize, regulate, and restrict access to marijuana in a careful and orderly way. And in accordance with our approach to inclusivity, we will take the time necessary to get this right. In the coming months, our government will be establishing a provincial federal task force that will hear from experts and recommend a Made in Canada approach. I will be working with my parliamentary secretary, Mr. Bill Blair, supported by the Ministers of Health and Public Safety, to design a system of strict regulation with strong sanctions that keep marijuana out of the hands of children and the profits out of the hands of criminals. Next, medical assistance in dying, another highly complex social and legal issue, one that we must address in a timely manner due to the imposed timeframes of the court. Much has changed since Sue Rodriguez's case in the mid-1990s. The Supreme Court of Canada has spoken in Kay Carter and Gloria Taylor case. And while there will never be full agreement on these issues or the issues involved, we must strive to achieve consensus on the response that we will present to Parliament in the coming months. While we did get a 4-month extension from the court-imposed deadline, we must and are working diligently to have a solution in place by June the 6th. Despite the time crunch, we have made good progress. Last year, both federal and provincial external panels of experts gathered evidence and listened to the views of a broad range of Canadians and international experts. And late last month, the Special Joint Committee on Physician-Assisted Dying released its recommendations. This was a parliamentary committee made up of members of parliament and senators that heard over 60 stakeholders, witnesses, and received submissions from thousands of Canadians across the country. Now, the Minister of Health and I are working with our caucus, our officials, and our parliamentary colleagues to design an effective solution. There are so many questions that need to be answered. What type of regime would best serve Canadians? How do we protect the autonomy of Canadians to make decisions about their bodies while also safeguarding the most vulnerable among us? How can we ensure access from coast to coast to coast while also protecting the conscience rights of medical practitioners? What kind of partnership can be forged with the provinces and territories, as well as with other stakeholders? Clearly, the best way to answer these questions is through careful and open collaboration among people with differing views, by looking at those best placed to help us work through these issues, by making relevant information readily available to Canadians and reporting on progress. We can create the environment that will position us to best achieve the best possible solution for Canada on this incredibly sensitive issue. So moving to another issue briefly, one which I am asked about quite regularly. How are we going to find the right balance between security and personal freedoms? This, of course, was a hot issue during the last election, continues to be as we consider then Bill C-51, the Anti-Terrorism Act. This is very much on our government's radar. Currently, I'm working with the Minister of Public Safety and Emergency Preparedness, Ralph Goodell, to review the problematic parts of Bill C-51, while providing the proper oversight and accountability. We will hold meaningful consultations on our national security framework, where the objective is to ensure the safety of Canadians while protecting our rights and freedoms, to find the right balance. So perhaps, however, the most challenging area of public policy our government seeks to address, but also necessary and long overdue, is true reconciliation with Indigenous peoples. Building the nation-to-nation relationship lies at the heart of a strong Canada and a task all ministers in our respective ministries and mandate letters have been given. We need to find long-term solutions to decades-old problems as we deconstruct the colonial legacy and develop, in full partnership with Indigenous peoples, a new framework for reconciliation based on recognition. With our government, there is now the political will and direction to make this a reality. Moving forward, one of the biggest legal questions we need to unpack is how we implement the United Nations Declaration on the Rights of Indigenous Peoples, and in particular, the concept of free, prior, and informed consent. The Declaration recognizes that Indigenous peoples have both individual and collective rights. It was, in fact, drafted with the participation of many of the rights holders themselves, some of who are in this room. Participation in real decision-making is at the heart of the Declaration's concept of free, prior, and informed consent, that Indigenous peoples must be able to participate in making decisions about matters that affect their own lives. There are many facets to the question, differing perspectives, and a number of options. All require a new relationship, rooted in Section 35, reflected in our unique constitutional requirements and our evolving federalism as shaped by the courts. This work will not be easy, not from any side or perspective, but anything worthwhile rarely is easy. The work will need to survive beyond the life of one government and will require a high degree of nonpartisan consensus. While my good friend and colleague, Minister Bennett, has the primary role to play in this work of reconciliation, it is clearly important in the roles of all departments, and particularly my own. For example, Canada is currently party to more than 45,000 lawsuits, of which over 10% directly address Indigenous issues. Many of these are here in British Columbia. These cases touch on all levels of government and numerous areas of jurisdiction, be it land management, child welfare, or the environment. These cases pose important questions about how we see ourselves as a society and a constitutional democracy. The Crown's position in these cases does affect the pace at which reconciliation can occur. Accordingly, as part of my mandate to review our litigation strategy, I have instructed my officials to seek additional time on a number of key Indigenous cases so the Crown can reassess its position. Moving beyond litigation, it is also critical that we do not simply make adjustments to the broken Indian Act system of federal administration. Instead, we must look holistically at the actions that have led us to this point and, based on recognition, develop new mechanisms to support Indigenous groups when they are ready, willing, and able to self-govern. While we cannot change history, we can learn from it, move forward, and lay the foundation for a better future. We must ensure that Indigenous peoples are able to realize their full potential, to contribute fully to their communities, to the economy, and to society as a whole. For me, one of the best ways to understand the change needed is to support this transition is to honestly and fully confront the ongoing national tragedy of murdered and missing Indigenous women and girls. Many women and girls are certainly victims of crime, but the issues extend well beyond our criminal justice system. For too long, Indigenous women and girls have been and remain one of the most vulnerable groups in society. And surely a critical measure of a just society is how it treats its most vulnerable members. Our government has now held pre-inquiry meetings across Canada with survivors, family members, and loved ones of victims, as well as representatives from provincial, territorial, and Indigenous governments. This work is now informing the design and scope of the inquiry, as well as the actions to follow, and those that we can continue to do right now. What I can tell you is that the inquiry must provide a measure of justice to the families and honor the lives of the murdered and missing Indigenous women and girls. Further, it will examine the systemic barriers that exist within our institutions while looking at the root causes of why this situation exists in the first place. As we move towards the 150th anniversary of Confederation, the 35th anniversary of the Charter, there can be no better way to celebrate the spirit of these important milestones then by reconciling with Indigenous peoples and working to complete the unfinished business of confederation. We can and will redefine our relationship in a fundamental way. Indeed, the way that we address Indigenous issues in this country, I am sure, will be one of the lasting legacies of our government. Finally, and relatedly, I want to turn to criminal justice reforms that we're trying to achieve. As mentioned earlier, these will be part of an overall re-examination of the criminal justice system, which must be based on evidence and on principle. In this context, there are 3 areas that we will examine. The first is that our current criminal justice system disproportionately affects the most vulnerable segments of our population. For example, and as we probably have all read in Maclean's, we know that Indigenous peoples interact with the criminal justice system in shockingly high numbers. Indigenous peoples are far more likely than other Canadians to be arrested, prosecuted, and incarcerated. Last year, Indigenous peoples comprised more than 20% of the federal inmate population, despite the fact of only making up 4% of Canada's population. And the numbers keep getting worse. The number of Indigenous peoples behind bars has increased by 17% in the last 5 years, up 112% for women. According to the last figures available, more than 36% of adult women sentenced to custody in this country were Indigenous. Clearly, the number is 9 times too high. As a former Crown prosecutor, the story is unfortunately all too familiar. A young person, all too often an Indigenous male, commits a non-violent property crime, comes into contact with the justice system, and never leaves. He's caught in a vicious cycle of court appearances, court orders, breaches of court orders, and returns to custody. So the young person is spending more time behind bars than in their community and has little hope of breaking the cycle. To be clear, the examination of the criminal justice system will not focus solely on how we treat Indigenous peoples. The truth is that many offenders have some combination of mental illness and addiction. Up to 80% of all federal offenders have past or present substance abuse issues. Some studies indicate that 2/3 of all crimes are committed while under the influence of alcohol or drugs. So let us imagine a Canada in which the justice system better aligns with the needs of all Canadians. What if an offender's first interaction with the criminal justice system did not become the first in a series? What if it triggered mechanisms designed to address the factors that inspired the criminal behavior in the first place? What if we intentionally and deliberately built off-ramps to the system so that the individual's first interaction with the justice system gave them avenues to pursue and to ensure that it was also their last? Clearly, we need innovative solutions. And, Minister, there are innovative solutions. One of these is to consider greater use of restorative justice measures and other alternative measures to incarceration, where appropriate, such as sentencing circles. These measures seek to make both the victim and the offender active participants in the journey for justice. It emphasizes repairing the relationship between the victim and the offender. Victims have a powerful voice, and this process allows them to heal, while at the same time focuses on the offender taking important accountability for their actions. These measures are proven effective. In 2011, the Department of Justice report found that Indigenous people who completed a community-based alternative to mainstream justice were significantly less likely to reoffend than those that did not take the program. Another innovative way to break the cycle may be through specialized courts, including First Nations courts, community courts, and drug treatment courts. Community courts use case management to help offenders make long-term behavioral changes. Here in Vancouver, the Downtown Community Court hears a wide variety of cases except for those most serious, and tailors the sentence to the offender and the offense. Courts like drug treatment courts, also here in Vancouver, integrate justice, health, and social service agencies in an attempt to modify the offender's behavior. A study of this court showed that the risk of reoffending among participants was reduced by more than 50%. Restorative justice measures like restorative justice programs and specialized courts are more collaborative and inclusive, more culturally relevant, and more likely to meet the needs of the communities they serve. Moreover, because they look at solving the problem that caused the behavior in the first place, rather than just punishment, they can give offenders a way out of the system where appropriate. The second area to closely examine is what we define as a criminal offense, while remaining vigilant about those truly serious offenses to ensure that resources are dedicated to the right things. Our system continues to be bogged down by cases involving relatively minor, nonviolent conduct and administration of justice offenses, often committed by a group of prolific offenders whose criminal conduct is driven by particular factors such as addictions or health and social problems. How the criminal justice system responds to this conduct requires careful consideration. This work could include looking at how we treat criminals, or, for example, how we respond from a sentencing perspective. It also should look at the important role discretion plays in the criminal justice system. Currently, the justice system devotes most of its resources to administration of justice offenses, such as the failure to appear in court or breach of parole. In 2009, these cases accounted for 21% of all cases and cost taxpayers an estimated $729 million. And most involved chronic offenders caught up in this vicious cycle I spoke about earlier. Clearly, this is not a good situation. Only through careful examination of what we classify as a criminal offense can we recalibrate our efforts and resources of the justice system to address serious crimes. This could have the biggest impact and produce the greatest results for Canadians in reforming our justice system. And the third and final area to reflect on is the rate at which the world is changing. The criminal justice system must keep pace with this change in order to meet the needs of our society. For example, technology has created new opportunities for criminals. Statistics suggest that cybercrime is increasing in Canada. Between 2011 and 2013, the RCMP saw the reported incidences of cybercrime increase by more than 40%. And incredibly, 1.75 million Canadians reported that they had been cyberbullied, but only 7% of victims reported the incident to police. Issues like cybercrime, cyber fraud, online crimes against children and minors, and the protection of online privacy have never been more prevalent. Our justice system must address these new issues and be able to react quickly while remaining true to Canadian values. And so finally, before I close, let me say this. Our constantly evolving society is underpinned by our justice system. The common and civil law must continue to reflect our values, and they must keep pace with our society as it advances. So too must the laws enacted by Parliament and other lawmaking bodies. We must have a living system of multi-level governance and cooperative federalism alongside an independent judiciary. And Canada's continued success absolutely depends on including multiple voices in the conversations we have about the type of country we want, increasingly involving those who may not have been part of the conversation before. I am convinced that more involvement will lead to richer outcomes, informed by the diversity of perspectives. This is how we must forge solutions and build a stronger Canada. As I said, I'm truly honored to be the Minister of Justice and the Attorney General of Canada at this incredibly important period in our history. and I look forward to giving back to our country through public service. In terms of public service, and I am looking at Mr. Basran, our Regional Director General for British Columbia, I am grateful to the thousands of public servants in my department. Their work not only supports me in my role, but it also, more importantly, protects the integrity of the justice system, in which protects our way of life. I have great aspirations for this country. I know that this country has not yet met its full potential and is still a work in progress. And while I'm seized with the urgency to act quickly and deliver meaningful results for Canadians today, we must ensure that we get it right. Working together, we can and will make a difference. Gaila Kasla, thank you for having me here today. Thank you very much.
So I have some remarks written down here about how I should thank Jody Wilson-Raybould for these inspiring words, but it's kind of a different situation in that normally I think people just say that at the end. They say, well, thank you for your wonderful words and so on, but these really were inspiring words. Thank you very much. How many times in your life, really, when you're working in a profession like the legal profession, you actually get to think, yes, things might change. It's wonderful to hear. Thank you very much. So thank you on behalf of the Allard School of Law and University of British Columbia. I'd like to thank you for your words. And everybody else is welcome to stay. There's refreshments out in the foyer area just outside the doors. Thank you again.